Okay, guys, I'm going to read the opening part. Or no, well, does somebody else want to? I mean, let's see.
I'll read it.
You will? Okay, so just if you could read just the case number and everything else. And that's it. Oh, and Casey, can you please still be the court clerk again?
My phone was
All right.
just freaking for a second. Hold on, it was just freaking. Yes, I can. Absolutely.
Okay, great. All right, let's get started.
Okay, comes now case number BD 621137. Case name Reed Randoy, petitioner versus Marieke Randoy, respondent. Hearing date Wednesday, July 5th, 2015. Before Honorable Tamara Hall Judd is the judge. Barbara A. King is the court reporter. Appearance is 3:45 p.m. The petitioner Reed Randoy, present with counsel Nicholas A. Silic, attorney at law for the respondent. Marieke Randoy, present in propria persona.
Let's call number 24.
God damn.
Randoy versus Randoy.
Sorry, I'm just gonna.
Yeah,
I'm
I was
gonna
gonna say,
mute
do
the
you
other
want to
people.
start?
What?
Is everyone muted?
Yeah, just make sure. I believe I muted everybody. Okay,
They want-
go ahead.
Does
Okay.
the court want to start again?
I will. Let's call number 24, Randoy versus Randoy.
Good afternoon, Your Honor.
Appearances, please.
Good afternoon, Nicholas Salick for petitioner who is present at council table.
Marieke Randoy, present.
Thank you. Can you swear the parties, please?
Please raise your right hand. Do you swear to tell in front of the court today that you'll tell the whole truth, nothing but the truth? So help you God.
I do.
I do.
Okay, thank you. Okay, we continued this matter from last week until today, June 26, 2015, until today. And I had an opportunity, first of all, you're here, and I had an opportunity to review the law regarding the issue that the respondent raised, whether or not the court has jurisdiction to make custody orders, and whether or not we are the home court, or whether or not Canada is the home court. A court in Canada is the home court, and I will hear from you, counsel, but based on the court's review of the law, the matter appears to be correct, that we are not the home court. So I will hear from you. First, let me ask you, ma'am, have you started proceedings in Canada?
Yes.
And you have a court date, and in Canada, has a case been filed?
A case has been filed, so he still needs to be served.
Okay,
But because he lives on a boat and because he does have an attorney,
okay.
I guess the plan is just to serve the attorney.
No.
No, just one moment. Just listen to the question the court is asking.
Yes.
So a case has been filed.
Yes, ma'am. I have it right here.
Has a case been assigned to a judgment in Canada?
I have it's called the Notice of Family Claim, and it's with the Supreme Court of British Columbia. It's got a Vancouver registry number. I don't understand it. It's very different than it is here, but place of travel, the Vancouver Law Courts, it's got the address. Let's see if it has an actual date.
Okay, my question is, has a judge been assigned to the case?
I don't know yet, but I do know that it's already on file, and I just think we need to serve him first. But about the actual judge yet, I don't know. On this paperwork, it doesn't seem to state the name of a judge yet.
Okay, so Family Code section 3421 reads as follows. California has jurisdiction. This is initial custody determinations. California has jurisdiction to make an initial child custody. Family Code section, initial child custody determination only if any of the following are true. 1, California is the home state of the child on the date that the family law proceedings are commenced, or was the child's home state within 6 months immediately before the commencement of the proceedings. If the child is not in California, but a parent or person acting as a parent continues to live in the state. Home state is defined as the state in which a child lived with a parent or a person acting as a parent for at least 6 consecutive months immediately before the commencement of a child custody proceeding. So that's why I inquired. That's why I'm inquiring of counsel. Do you wish to be heard?
Yes, thank you, Your Honor.
And normally that's, and before I have you address the court, normally the court here would have a consultation with the other judge, but that's why I asked you, ma'am. Has a case in Canada been filed, and has it been assigned to a judge so that this judge could have some type of conference with the judge in Canada? But you can't answer that because you don't know if a judge has been assigned.
Your Honor, may I look at her paperwork to see maybe if I could?
Yes.
I do have an attorney in Vancouver, so I could get that answer to you very quickly.
Okay, so shall I read?
No, review it. If you see that a judge that I could call, then we could have a conference.
This was filed June 26, 2015. It does say on page 2, it does recognize, I'm sorry, it does set forth that there is a related prior court proceeding. So this case number is listed.
Our case number is listed on those papers?
On the second page, yes, under prior court proceedings and agreement, and the box is checked, one or more of the following relates to claims made in this notice of family claim. And there is 2 boxes checked. One says a court order dated June 15th, 2015. And the box underneath says a prior court proceeding with the BD 621137 and identifies this proceeding. It says the place of trial will be Vancouver Law Courts. It has an address. There is a lawyer's name. No, it's going to be the last page that I look at.
Those are my notes. That wasn't part of it.
This was it. There is nothing else.
Yeah, no.
It doesn't appear to list a court date. It lists the court address, and it has a case number. Maybe it's like in California, we file a petition and then you get assigned to a courtroom. Then,
Okay.
Your Honor, this is I'm handing the forms back to the respondent. This is a very technical area. And frankly, I thought that after last Friday that this issue was resolved. I understand the court revisited that, but I mean, there's a proper procedural issue. One is petitioner filed, the person then served respondent. The respondent then filed and served a response. And it seems as if the Canada family law case was filed after she filed her response.
Well, see, if we're dealing with 2 different things, your client filed, the parties are married. He filed his petition for dissolution of marriage on May 19th, 2015. And the respondent filed her response sometime thereafter. And
I have a June 18th.
okay, June 18th, 2015, and you did argue that jurisdiction. I'm summarizing, but you argued jurisdiction wasn't moot because she filed a response. And I listened to that argument. I considered it. But then on further reflection of the law, what is being asked of the court at this juncture is not issues. Resolving issues pertaining to the dissolution per se, but it's pertaining to custody orders. And in an ex parte, when there's an ex parte before the court can make temporary, the court does have temporary emergency jurisdiction, but the court already made the ex parte orders on June 5th, 2015, continued this matter to June 26th, 2015, heard both sides, found that for reasons already stated, there was no exigent circumstances. So then the next step is to go to making an initial child custody order. And that's where the jurisdiction issue is raised again. And that's where the court cannot ignore that issue, because in order for the court to make an initial custody order, initial child custody orders, the court must first have jurisdiction. That's under the Uniform Child Custody Jurisdiction Enforcement Act, UCCJEA. And that's Family Code Section 3400 through 3465. And so yes, you're correct. The court put this matter over for several reasons. But the court, again, it stopped and reflected, and I first have jurisdiction. That means the authority to make an order before I make an order.
May I be heard?
Yes.
Thank you, Your Honor. There's a case that came down last year. It's called Murphy versus Sloan. It's 764F, as in Frank, 301144. And that was out of the Ninth Circuit. And the facts of this case, I read it between the last hearing and this hearing, are almost, if not spot on. And so if I understand the court's concern, it's extremely legitimate. Obviously, the court cannot make custody orders unless it has jurisdiction. But before that determination is made, whether or not the court has jurisdiction, I think it has to have more facts and information. And one of the contentions between petitioner and respondent is that petitioner contends that mother's move to Vancouver was temporary. It was a trial period. Respondent says otherwise. We have text messages where respondent is admitting, I'm moving back. There is an intention to relocate back to California. Therefore, just like in Murphy versus Sloan, in that case, there is also a trial period. In that case, there was also a 2-year gap. But the court, the Ninth Circuit Court of Appeal, found that because it was a trial period and that there was this intention, it wasn't permanent. There was a possible intention to come back. That, therefore, jurisdiction was not relinquished by the court. I don't know. Well, in this case, the court was not, California did not relinquish jurisdiction. It was a trial period for approximately a year that respondent was, the parties agreed that she go up there and try to earn film credits. And around April or May of this, that was April of 2014 is when she moved to Canada. So April 2015 or around April 2015, respondent communicated with petitioner that she was going back. And then we have a text message, May 22nd, 2015, in which she texted petitioner. Respondent texted that she has intentions to move back. She just needs film credits. But the trial period was for a year, and it was for her to get the film credit. And if she didn't make it, then she would come back. Hence, that's why petitioner has his houseboat and all of the assets weren't sold. I implore or request the court read that case. It's actually quite spot on. And if further briefing is necessary, then so be it, which is fine because this is a very, very important issue. And I think that the court should have, because we didn't know that we needed to brief this issue. We were often ex parte.
I'm sorry.
I said we didn't know we needed to brief the position because what we filed was an ex parte RFO. So the hearing is often ex parte RFO. It's not a RFO challenging jurisdiction. So we haven't properly pled this or responded to it.
Okay, let me say this again. The court, you filed an ex parte asking for emergency orders. The court granted those emergency orders, had the hearing, heard from the respondent, made a determination that there wasn't an emergency. So now it becomes initial custody orders. What the court can do, because as you just accurately stated, since there is no initial, the court finds there is no emergency. The court does not have to make any orders at this time. The matter is just off calendar, and either side could file another request for initial orders. Ordinarily, what judges do when there is an ex parte, and if it's determined that there is no emergency, the court will just go right ahead and make initial orders. What makes this case unique, I don't know about the case that you have just cited, but what makes this case unique is that jurisdiction it is an issue. And I don't know what that case says, but I do know that what the California statute says, that this court is bound by, and it simply states that there must be first a determination of whether the court has the jurisdiction to make initial custody orders. This would be moot if this was a temporary emergency. Temporary emergency orders, and the court has already made them and found that there was no emergency. So we can treat this as the court will take it off calendar and the parties can start all over, or you could have an opportunity to brief the issue, but it's not very much to brief. I need to know the name of the judge, who this case is being assigned to, and I need to have a conversation with them because that is what this court is bound by. It is very clear. It says 3421 of the Family Code section, California is the home state of the child on the date. Strike that. California has jurisdiction to make an initial custody or child custody determination only if any of the following are true. 1, California is the home state of the child on the day that family law proceedings are commenced, or was the child's home state within 6 months immediately before the commencement of the proceedings. If the child is not in California, but a parent or person acting as a parent continues to live in the state. These proceedings with respect to the ex parte commenced on, let me see, the ex parte was filed on June 5th, 2015. They commenced on that date. home state jurisdiction has priority over all other bases for jurisdiction. Home state is defined as the state in which a child lived with a parent or a person acting as a parent for at least 6 consecutive months immediately before the commencement of a child custody proceeding. In the case of a child less than 6 months of age, the term means the state in which the child lived from birth with any of the person mentioned. A period of temporary absence of any of the mentioned persons is part of the period. Family Code Section 3402G. Number 2, a court of another state does not have the jurisdiction under 1, i.e. another state is not the home state, or a court of the home state of the child has declined to exercise jurisdiction, because California is a more appropriate form, and both of the following are true. A, the child and the child's parents of the child, and at least one parent or a person acting as a parent, has a significant connection with California other than mere physical presence. And B, substance, strike that. Substantial evidence is available in California concerning the child's care, protection, training, and personal relationships.
Your Honor, I'm sorry, what code section are you reading from?
I'm reading 3421 in its entirety. 3, all courts have jurisdiction under 1 and 2 and have declined to exercise jurisdiction on the ground that California is the more appropriate forum to determine custody of the child. Or 4, no court of any other state would have jurisdiction under paragraphs 1, 2, or 3. Then if you look at that 3405, foreign countries, just one moment, and it states, a court of this state shall treat a foreign country as it were a state of the United States for the purpose of applying this chapter in chapter 2, commencing with section 3421. That's a 3405 subsection A. Subsection B. Except as otherwise provided in subsection C, a child custody determination made in a foreign country under factual circumstances in substantial conformity with the jurisdictional standards of this part must be recognized and enforced under chapter 3, commencing with section 3441 and 3405. C, a court of this state need not apply this part if the child custody law of a foreign country violates fundamental principles of human rights. So the threshold question is, who is the home state? And 3421 subsection 2 will allow this court to be the home state if, again, I will read the law, a court of another state, i.e. here Canada, treating it like it is a state of the United States, does not have jurisdiction under 1, another state is not the home state, or 2, or a court of the home state of the child has declined to exercise jurisdiction because California is a more appropriate form, and both of the following are true. So in order for the Canada to exercise a decline, or whether or not they have jurisdiction, this court has to have a conference with Canada. I cannot just make a determination without first answering this threshold question. So that's where we are, because you are asking the court to make initial custody orders on your ex parte request for order. Go ahead.
Yes, the ex parte, I believe we did ask for a request for order shortening time to set a formal hearing or a full hearing. But to back up, under Family Code 3421A1, it says that California has jurisdiction if this is the child's home state, or was the home state within 6 months prior, before the commencement of the proceeding. The case that I cited, the Murphy versus Sloan, that's why I believe the case is spot on in this case.
Counsel, let me stop you there.
Yes.
One thing I don't do, or one thing I know I do for sure, is I follow the law. I know what I have to do. This is a threshold question this court has to answer. I have to have a conversation with the judge in Canada, a conference with the judge in Canada. I will review your case, but I'm letting you know now that that case, whatever it holds for, are you stating that it overrides, it overrules the UCCJEA?
Not at all.
Okay,
But what I'm saying, what the case does is it would help, it helped me, and I believe it would help the court define which state is a child's home state and see.
counsel, that's what I'm trying to explain to you. It's not a decision that this court unilaterally can make. Based on my reading of the law and my understanding of jurisdictional issues, this court has to have a communication with Canada, a conference with Canada.
I hear that part.
Okay,
I understand that part, but what I was arguing, and I won't argue it again, was that California was not given up, abandoned as the child's home state, because the reason why the respondent was up in Vancouver with the child is for a trial period. And the trial period expired, and according to petitioner, she decided that she wanted to stay there. That doesn't mean that that trial period is suddenly eliminated and she gets to stay in Canada. If the intention was to come back, if it didn't work in Canada, then California was never abandoned as the home state. And that's what the case identifies. Whether there was an abundant or whether there was an intent to return or whether it was abandoned.
okay.
And I could cite the case again.
I will take the side. But before I take the side, where did that child in that case reside 6 months prior the proceedings were filed?
In that case, the parties were American. There is an agreed upon trial period that mother would move with the daughter, to Ireland. And I believe for the next 3 years, the child attended school in Ireland, but frequently returned to the United States. And then father went to visit and realized or discovered that mom did not want to return or was not going to return the child. I think she was going to take the child to Asia instead. So he took the child to United States. And then the mother is, I believe, was the moving party. She is the one who then filed an action under the Hague Convention claiming that father abducted the child. And the appellate court said, no, there was no abduction because it was a trial period and therefore the United States didn't have jurisdiction.
Okay.
Or California.
Okay, so that's your argument that, oh, okay, I hear your argument. What's the crime?
It's 764.
764. Ma'am, you may want to take this.
F as in Frank, V, D as in David, 1144.
1144, the name of it.
Ninth Circuit, 2014. Did you say the name?
Just one moment. Ninth Circuit 2014. What's the name of the case?
Murphy, M-U-R-P-H-Y versus Sloan, S-L-O-A-N.
Sloann.
No, just one N, S-L-O-A-N.
Okay. So the court will read Murphy.
And with respect to, it seems as,
Okay, so the court is going to read that, and
then with respect to the conference call with the Vancouver judge, I would like to put the onus respondent. Apparently she has an attorney in Vancouver. The attorney's name is on the papers that I was reading before on the record. Perhaps her attorney in Vancouver could communicate with me so I could provide the court with the judge's name.
no, that's her responsibility. She's going to have to provide the court with the name of the judge. I don't need your lawyer's name or his telephone number because the courts do not communicate with lawyers, and you are to provide the same information you're going to provide to the court. You're to provide that to counsel for the petitioner, and you are to provide your lawyer's name and telephone number in Canada to counsel for petitioner. But all the court needs is the name of the judge, the department. If you could write this down, please.
Uh-huh.
I need the name of the judge, the department, telephone number, an email address, and their business hours. I'm not assuming that they have the same business hours as ours. Okay, and so their argument, ma'am, counsel has summarized the case. Their argument is that when you resided, both of you along with your child resided in Canada, it was for a temporary basis and with the intent of returning to California. Therefore, this court is the home court and has jurisdiction. That's your argument based on Murphy, correct?
Correct.
So the court is going to review Murphy. I would advise you, ma'am, to review Murphy. I don't know if you have a lawyer here in Los Angeles, California, but I think you should have a lawyer. So we are going to continue. Did you have something?
Yes, I definitely do. Contrary to what counsel just said, I like the word unilateral. This was not a unilateral decision to move up to Vancouver. It never was. We decided to move up as a family. My husband is an actor. He wanted to go up there and audition as well. The idea was for him to come every weekend, but as soon as we moved up, he changed his mind. From May until September of last summer, instead of selling all of his things, what he wanted to do, make a sacrifice and decide, you know what, I'm going to focus on my acting career instead of doing what he spent $20,000 on boats and cars. He did not come up to visit his son and his wife that summer. He partied with women on his new boat. He got a third share on a new boat, a third boat, and bought a new car. Everything that he is doing is out of spite. It's not out of whether he wants to see his son more. The suggestion that I made was, because of the nature of, his complaint is he can't just come every weekend. He doesn't know when he works next. He works 2 days here, 3 days there. He only knows 1 or 2 days in advance when he's going to work. My suggestion was tell your booker, just pick 5 days out of the month to come see your son. Book it well in advance. This way you can take trips with the grandparents. You could come and you could plan your trip. You could take the time off. You look on your calendar, right? And you could spend some quality time with your son. And it's just one trip, right? And you could go anywhere you want with because his mom is a travel agent and the other set of grandparents, they travel a lot. They're wealthy. He could do all kinds of things. The other side of the family is in Seattle, which is just a 2.5 hours drive away. If he booked off the 5 days, then he would see his son every single month. And then he works 15 days out of the month. And he needs 5 recovery days because when he works, he barely gets any sleep. He comes home at 11 at night, and then he has to get up at 3 o'clock in the morning to get back to the set, right?
Okay, let me stop you there. Because all of the information that you're telling me, and council has further information, I am going to hesitate to say this, but I'm going to request further declarations from both sides.
Okay.
Stating your respective positions, why from the petitioner you think California is the home state, provide your supported evidence. And ma'am, your position why you think Canada is the home state and provide your supported evidence. And I need all of this information filed with the court before the next court date I'm about to give. And I also need the name of the judge. I am ordering you, ma'am, to provide that information to both the court and council on or before July 10th,
Okay.
2015.
And
the further declarations that the court is allowing from both sides that is due to be filed on or before July 17th.
Filed directly in the courtroom or?
Mark directly in the courtroom.
Casey.
The clerk, please.
Sorry, what was that again, Joy? My brain was so out, so I'm so sorry, that was my PTSD.
Page 18, line 21, the clerk.
I don't have that one. Don't have it.
That's
I'll read it.
okay. You'll read
I'll
it?
read it.
Thank
Yeah, I'll
you.
read it. The clerk, they could file it directly in the courtroom.
Yes, directly in the courtroom. And we're going to come back on July 31st because what the court intends to do, I need the information by July 10th so that when I have the information of the Canada judge, the name of the judge in Canada on the 10th, and I receive your additional paperwork on the 17th, I could then coordinate between the 17th and the 30th of speaking, having a conference with that judge. So if I don't receive the information, I need it by July 10th, okay?
last Friday, I came in late. I gave a memorandum of points and authorities, which was in support of the response declaration, and I gave a copy to Mr. Salick. I know you didn't get a chance to read it then, and you obviously didn't get a chance to read it since because I didn't file it correctly. I must not have filed it correctly. I just want to be sure that I do it correctly because this was just a memorandum of points and authorities to my very first response to his ex parte.
Okay, I don't need that because it wasn't that it wasn't filed correctly. It was filed late.
Okay.
So late filings we don't receive because I haven't had a chance to read them. Council has not had a chance to review them. What I'm asking now is information on this issue of jurisdiction, and
I cover all of it, so I'll just be refiling it.
so you will have to refile and just focus on the information that I'm requesting at this juncture. And whatever you are going to file, you have to provide counsel with that information as well.
With respect to the July 10th and the July 17th due dates, because I don't know where she's going to serve it from, could we do service by email?
Okay. Do you have each other's emails addresses?
Yes, which one should I, because we both have so many email addresses, can you do them Marieke Taylor at me? And then which one shall,
NAS at Salic Family Law.
So the parties have agreed that service will be by email. However, with the court, we don't have email. So you will have to file your papers with the court.
and with,
The court, you could file it inside the courtroom.
okay, in the courtroom.
Yes. So the information regarding the judge, if that could also be filed in the courtroom, July 10th, 2015,
And served by email.
and served by email, yes. July 31st, how many matters do we have?
The clerk, we have 15. Is it possible to set it at 1:30? I don't know if that would. The clerk, we have a backup date for a 217 on the 30th.
On the 31st.
The clerk, well, on the 30th, we have the 217, and then we set the 31st as a backup in case it does not finish.
Okay, you need a 1:30?
Mr. Salic, no, I was just wanting to know, just to limit, because I changed him, if it would be better for all involved to come at 1:30, otherwise 8:30 is fine. Let's make it 8:30.
I mean, it could be 1:30. We have another matter on calendar, but I hear what you're saying. It's easier and more efficient for your client, for you to sit from 1:30 to 4:30, as opposed to from 8:30 to 4:30.
Plus, it's basically a law and motion type thing. I would think it wouldn't take too long.
So it's up to you. We could set it for 8:30, or we could set it for 1:30. We have 15 matters in the morning.
The clerk, yes.
We could set it for 8:30, and I'll give it priority. I'll call the case. If everyone is here at 8:30, I call it first. Just remind me that I said that if you want to do it at 8:30.
Mr. Salic, yes, please.
So July 31st, 2015 at 8:30 a.m. This case the court will give priority. So just remind the court that I said that, so this case will be called first. And we'll see everyone back on that date. Counsel for the petitioner, if you could give notice.
Do the proposed order and notice, or can the minute order be the order after hearing?
Well, there are no orders made today, so just notice.
Okay,
Or is notice waived? Notice essentially stating that you will receive in the mail either from counsel or from the court from the court regarding what the court ordered today in terms of further declarations on the issue of jurisdiction. I need the telephone number of the judge in Canada, who this case is to be assigned to by July 10th, 2015. And I've ordered the parties to file further declarations regarding the issue of jurisdiction to be filed on or before July 17th, 2015. The parties have agreed that they could serve each by way of email, and your order to be here July 31st, 2015 at 8:30 a.m. The court will attempt to have a conference with the judge in Canada between July 17th, 2015 and July 30th, 2015. So if we were to give you notice, ma'am, that's essentially what the notice will say in your order to be here on July 31st at 8:30 a.m. So is notice waived?
Yes.
Okay, counsel, is notice waived?
so waived, thank you.
So we'll see everyone back on that day.
Your Honor, last Friday, you made some orders for joint custody, and you ordered my husband to take custody of my son on Fridays at 3 p.m. through Monday, 8 p.m. My husband didn't see his son this past weekend.
He couldn't afford it.
That's because he's such on this ex parte. He's cut me off.
Okay, well, this is what the court is going to do at this time. Because the issue of jurisdiction must be dealt with first, orders that the court made on June 26, 2015 regarding custody and/or visitations are vacated at this time. And this ex parte is being continued until July 31st, 2015 to determine whether the court, 1, has jurisdiction, and 2, make initial custody and visitation orders. Okay, now, if the parties could work out something between now and July 31st, 2015, so that each could see your son, that would be wonderful.
And if we could just have it on the record.
I could take my son back up to Vancouver, right?
The fact that this is continued to July 31st, the address on the back of the summons are still in effect.
Yes.
So the child, Hunter, cannot leave the state of California unless there is a written permission from the petitioner or there is a court order, unless they work something out.
May I at least argue, since we're here, could I at least argue my case for just a second?
You can, yes.
Thank you. According to section 152.208, the court may decline jurisdiction if the person seeking to invoke its jurisdiction has engaged in unjustifiable conduct.
What section is that? What code?
This is from the same Uniform Child Custody Jurisdiction and Enforcement Act, section 152. Okay.
Is it family code?
Yes.
Is it a family code section?
Yes.
What section?
There's two things. There's two things I would like to argue. Section 152.208, jurisdiction declined by reason of conduct, and section 152.207, inconvenient forum. Courts of the state, which is jurisdiction under this chapter to make a child custody determination, may decline to exercise its jurisdiction at any time that it is an inconvenient forum under the circumstances, and that the court of another state is a more appropriate forum. The issue of inconvenient forum may be raised upon motion of the party, the court's own motion, or a request of another court. Should I show you where it is, or should I continue reading?
Well, you could continue to make your argument.
Thank you. Before determining whether it is an inconvenient forum, the court of the state shall consider whether it is appropriate for the court of another state to exercise jurisdiction.
Your Honor, I'm going to interrupt. She's reading from the document which was filed late last time, and she's represented to the court. She's going to refile. So she basically arguing what we're going to talk about on July 31st.
You just brought up a case, which is why we're extending this entire thing. I'm sorry, but you know what?
Let me stop you there.
If I may, especially that, I'm so sorry, but especially further by reason of conduct.
Okay, let me stop you there. I've heard what you've said, what you just read.
Yes.
Inconvenient forum.
Yes.
But I need you to really understand, before the court could even make that decision, if I'm going to decline that, this is the inconvenient forum, California, I first have to have the jurisdiction to do so.
That I completely understand.
I don't know if I have the jurisdiction to do so. That's why this matter is being continued. It's not because counsel brought out a case. Counsel was doing his job in bringing out that case. He anticipated maybe the court will revisit the jurisdiction issue. So let me be prepared with points and authorities to help direct the court or give the court something to review in its determination. That's why he brought the case. It wasn't just, let me spring this on you.
Okay.
That being said, so before you could argue what you're stating and you want me to consider that, I first have to make the determination of whether or not I have the jurisdiction, the power, the authority to say I don't want to hear the case here because Canada is a more convenient forum, or I don't have jurisdiction because the Canada court said they have jurisdiction. I first have to answer that question, okay?
Okay.
That being said, however, see, we're working on two different things. The odds still apply because when he filed his petition for dissolution of marriage and you filed your response, long before you filed your response, there is a summons. In the address that I read to you, it states, once a petition is filed, there are things that the parties cannot do. And what you did is you violated the address by removing your child from the state of California. So to this point, you have to keep this child. The child has to remain in the state of California because you are in violation of the address.
Where is he going to live?
Now, that being said, where are you going to live? Where your child is going to live? I don't know, but I just know what the law is.
Can I give you a couple of laws that are in my case, please? Just the Hague Convention that he mentions applies when a child under the age of 16 at the time of a hearing has been wrongfully removed to or retained in a country. The child's habitual residence, it's really important, immediately before the removal was in another, as in the United States, and the child was removed or retained from a personal institution or body that has and was actually exercising lawful rights of custody, or that would have been exercising lawful rights but for the removal of the child. And then it says, it states where it is, where could you find it? When deciding whether children have acquired new habitual residence, courts must focus on whether both parents, not the child, had a settled intent to abandon the previous residence. The objective of the Hague Convention is to prevent parents from engaging in gamesmanship with the child's upbringing in order to secure an advantage in an anticipated custody battle. Because Hunter Randoy is under 16 years of age and a habitual resident of Canada prior to the divorce proceedings, the Hague Convention applies, and respondent is exempt from complying with the standard temporary restraining order that follows with the summons.
Okay.
He also, with the summons, ma'am, he lists Vancouver as our residence for over a year for the three of us, husband, wife, and child for over a year.
Actually, there's two addresses listed there for the same period.
Yes, a UPS mailbox that our son was never at. He lied.
Okay. There is no petition before this court for a habeas corpus for a Hague Convention hearing. Those take place only in Department 2. So you're citing law that it sounds like it's on your side, but I don't have before me, again, a petition for habeas corpus Hague Convention. That is something you will have to file, and you will have to file that in Department 2. That being said, what I do have before me is a petition for a dissolution of marriage by the father. He served upon you the address which state parents cannot remove the child out of the state of California, and you did so. So that's in violation, and I'm ordering you to remain in the state with the child.
I have no money. I don't know what to do. How am I supposed to live? In a shelter? Seriously, please tell me what I'm supposed to do.
I can't tell you what you're supposed to do. I could only state what the law is.
but I believe the law is in my favor. I believe what he's doing is complete and utter abuse and harassment, and it's not in the best interest of the child. We have a home in Vancouver that he paid the rent for.
Okay, let me ask you this question.
At least until the next hearing, can we go home?
Just one moment, just one moment. Let me ask you this question. So do you have a place of residence for Hunter?
Yes, I do.
How old is Hunter?
3.
Okay. Do you have a place of residence for his mother?
Your Honor, one of the things we're going to request is a nesting order. There is a 1-bedroom furnished
Okay.
guest house, and then my client petitioner has the boat. So what they could do is Hunter could stay in the house, and then
This is the same.
and the custodial parent could be in the house, or the non-custodial. The petitioner could be on his boat, and I don't know where the respondent will go, but there is a place where Hunter could sleep.
My question is, do you have a room for the mother to stay with Hunter in the United States, California, LA County, yes or no?
Yes.
Okay.
Ma'am, that's not our home, and these are the people that accused me of a felony.
Okay.
I'm not welcomed there. That's not my home. I don't have a car there. I don't have anything there. Just for the safety. Listen, can I show you the bedroom that I made for my son? It's a tree house. Like, he kept me here on my friend's couch for almost a month. I wrote a letter he actually had it as Exhibit A, okay?
Okay, we have to end. So we're going to end, but the court is going to find good cause for this limited purpose. Mother will be able to return back to Canada with child.
Thank you.
And your order to return back July 31st, 2015.
Wait, Your Honor, my client hasn't seen, he hasn't had,
He spent all of his money on you.
okay, Your Honor,
I need you both to understand. I cannot make any custody orders. I don't know if I have jurisdiction.
but the court just said that mom can't leave the state with the child, and now the court is saying that the mom can leave the state with the child,
Of course.
but that deprives my client from seeing the child.
No, you can. You could get on a plane anytime. I've never stopped you.
She's threatened to file a restraining order.
I won't. Of course not. You could come see your child anytime you want.
The court is going to make this order and you are done, ma'am. You are in violation of the address. The child has to remain in California because you're in violation of the address.
Then does my husband have to take care of him? Is he taking care of him then with a nanny or something?
Yes.
The court is not making any custody orders. I don't know if I have jurisdiction. The child has to remain here and the parents have to take care of the child until the court makes orders.
Thank you, Your Honor.
We are adjourned.
Unbelievable.
All right, guys.
Unbelievable. Holy crap.
Unbelievable.
Crazy, crazy.
You were brilliant, Marieke. You did
Yeah.
a fabulous job
I
And
know.
it's-
under unbelievable duress. But you know
Jesus.
what?
You came
This
back.
country is whacked.
Yeah.
Jesus, this back and forth. Holy
Do
cow.
you know, like what's really crazy is I restated the statutes that the judge said prior on June 26, 2015. Because a state, a foreign country is considered a state. You heard her say that on the first one, right? So she knows the fucking law. And I repeated it. And then she says, oh, but the ATROS says that you have to stay, you can't leave the state of California. Well, no, it doesn't say that. It says you can't leave the state. In other words, under the UCCJEA, my son cannot be removed from the state of Canada. You see what I mean? Like even the ATROS says that my son
It's
can't
so
be
weird
removed because
because she said you could, and then she said she couldn't.
I know she flip flops back and forth and back and forth and back and forth, right? She's
Yep.
crazy.
Yeah.
Yeah,
Marika, I'm sorry if I messed up you guys' the second part. I just had a really
No,
bad,
it's fine. Don't worry about it.
so I had to.
It's okay.
I
It's
couldn't
okay.
do it.
It's okay.
So we got 25 minutes until 6 o'clock. Do you want to, what,
Well, yeah, I
Right.
was just gonna ask you guys for just a brief opinion, like Lisa, Di, if you're there or nay, and listening to this, like if you were
I'm right.
just in a courtroom, right? Just listening there that day. I mean, what if you didn't even know the law and you were listening to
Yeah.
what we were both saying?
Facts. She said, I cannot make a custody order over and over and over again until she finds out who the judge is in Canada.
Right.
And then she made
So in my personal legal opinion, you should have been able to go back to Canada until
Well,
July
yeah.
31st.
Because she did make a custody order, didn't she now? She
Didn't
said,
say- Yeah.
Yes, she
And
did,
she's-
and I agree.
So she did, but she didn't.
Yeah.
Right? Because what I heard clearly was, yes, you can go back, but you are ordered to be back in this court on July.
Yep. And then she changed her mind. She
Yes.
flipped it. And you know what? In that proceeding, which is not, I'd love to get the recording of that. It's not in the transcript, but I said, but Your Honor, I have no place to go.
Mhm.
I have no place to go. Now you heard that part, right?
Right.
Well,
Yes.
what she actually
Marika,
said
you
in
hit
court
it out of
was,
the ballpark.
she
And
said,
Hit it out of the ballpark.
it even appeared.
I
as
can't
though
believe she didn't try to meet
they
you
didn't
halfway.
care about you, Marika.
what's that?
No, that's
They
exactly
didn't care
right.
about you.
No, but
No,
also,
she
do you notice?
contradicted herself. She contradicted her own self. the whole
You
time.
guys, her argument was, or do you notice how she's like arguing for the petitioner? Like like almost 50% of the time she's arguing their case. She said that I had filed a response and therefore I had accepted the jurisdiction of the
I
court,
heard that.
right? What she did not recognize and she didn't like to talk about was before I filed a response, I filed a special appearance declaration not accepting the jurisdiction of the court. And at that point, you have to file a response, or that was my, okay. And my response was, this court doesn't have jurisdiction, please vacate the fucking orders, okay? And also, if I did not file a response, as you all know, he would have gotten the default. So I'm damned if I do, damned if I don't. But the
Right.
first thing I filed before I fucking put one toenail into the court was I filed a special appearance declaration. And she, to this day, has not, or no, absolutely nobody has actually made a determination based on that particular special appearance declaration. She, I want to say too, like at the very end during the trial, I argued with the trial court, in front of Judge Riff saying, and I gave him the code section, which says, when you file a special appearance declaration, for as long as there is no ruling on that special appearance declaration, like an actual fucking evidentiary hearing, the court does not have jurisdiction. You see? And also, like any orders procured by fraud are void, right? And he has to have standing. You have to have standing. Over and over and over again, they talk about, oh, he doesn't have a residence. He doesn't have a residence. And, oh, do you notice how he said, well, we have a place for Hunter to sleep and